I was questioning a doctor at a pretrial deposition, and there were two defense lawyers there. One who represented the doctor whom I was questioning, and the second one represented a different doctor who I had a chance to question at another time. Now, during the course of my questioning, the second lawyer, who had no business saying anything other than objection, screams out, "Objection! I direct the doctor not to answer your questions. That's totally inappropriate." What? You want to know what this is all about? Come join me on this walk through the neighborhood as I'll tell you exactly why what this other attorney did was totally inappropriate. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, so here's what's going on. My client brought a lawsuit suing a number of doctors. There were two lawyers, two defense lawyers, who represented the various doctors whom my client had sued. The doctors, all the doctors involved in the case, claimed they did nothing wrong and that nothing they did caused or contributed to my client's injuries. That meant that now discovery would proceed forward. During the course of the lawsuit, my client had a chance to be questioned in a process known as a deposition. This is a pretrial question and answer session that typically, before COVID times, takes place in our office. In this instance, it took place over a Zoom call. Now, I am on the call, my client is on the call, the defense attorneys are on the call, and importantly, there is a court stenographer on the call to record all of the questions my client is being asked and all of the answers that she gives. Even though there's no judge on the call and there's no jury on the call, the answers that my client gives represent sworn testimony and carries the same exact weight as if she is testifying at the time of trial. Okay, so now after my client was questioned for a full day, a few months later, I now had an opportunity to go ahead and question this particular doctor. And you should know something. When I question a doctor, I have a certain agenda. I have certain key questions I will need to ask the doctor. I want to know what the doctor did. I want to know his rationale, his thinking for doing what he did. I want to know what my client complained of and what he responded. I want to know exactly what physical examinations he did. I want to know if he spoke to anybody. Did he speak to the client? Did he speak to the patient? Did he speak to the family? Did he speak to any other doctors about this particular issue? I need to know all that information. In addition to knowing the facts surrounding the events of the malpractice, I need to be able to ask the doctor hypothetical questions. In addition, I need to be able to ask the doctor to explain to me what is the standard of care when a patient comes in with the following problems. Doctor, a patient who comes in complaining of X, Y, and Z, would you agree that good medical care requires that you do 1, 2, and 3? And now the doctor will go ahead and tell me in his own words exactly what the standard of care was. Terrific. So now let's go back for a moment. I mentioned a few moments ago that it's critically important for me to be able to ask the doctor hypothetical questions. Now, why do I do that? It's because when we bring a lawsuit and the doctor denies all of your allegations, there are clear factual disputes. There are issues that are raised. There are clear conflicts that come up. The client, the patient says that the doctor did X, Y, and Z. The doctor said, no, I didn't. I did A, B, and C. And now there are factual disputes. So one of the ways to get around those factual disputes, other than my client saying, yes, the doctor did X, Y, and Z, and then I ask the doctor months later, doctor, what did you do? Did you do X, Y, and Z? And he turns around and says, no, I did A, B, and C. So how do I use those factual disputes to our advantage? One way is by using something called hypothetical questions. So I turn around and I say, doctor, I want you to assume that Mrs. Jones came to you on January 1st and she complained about X, Y, and Z. Would you agree that assuming those facts to be true, good medical care requires that you do 1, 2, and 3? And the doctor has to agree if those facts are true. And obviously he's going to disagree with me, but I am permitted and I am allowed to actually ask the doctor to assume that the following facts are true. And I'll tell you why we do that in a moment. So now I have an opportunity to ask the doctor very specific hypothetical questions based upon the facts that we believe to be true. So now I'm going to ask the doctor very specific questions. Doctor, I want you to assume that Mrs. Jones has testified that she came into your office complaining of A, B, and C. In that instance, would you agree it's appropriate to do X, Y, and Z? And again, he has to say yes, assuming those facts to be true. So let me explain one more thing. When I question a doctor, if the attorney who represents this doctor has a problem with the questions that I have asked, the attorney has an obligation to speak up and yell out, objection! Mr. Oginski, I don't like the form of the question that you asked. Please rephrase it. I'll say, sure, no problem. And now I'll ask it a different way. And if he doesn't like the form again, I'll ask it 10 different ways. Not a problem. Or if I ask a question that's totally improper and off the wall, the attorney will raise an objection and he'll say, objection, that question is palpably improper. I direct the doctor not to answer that question. Okay, that's understood. Also, if I ask the doctor a question about what he and his attorney spoke about concerning this case, that will generate another objection saying, objection, that is privileged information and confidential. You cannot learn that information. And you know what? He's absolutely right. Okay, so now what role does the other lawyer play when I go ahead and question this one particular doctor? I'll call him doctor number one. The answer is nothing really. That second lawyer who represents doctor number two and doctor number three, the only role that attorney plays is to sit and listen. If I ask a question that attorney number two doesn't like or thinks that my question might adversely impact her client, that lawyer has an obligation to go ahead and speak up and yell out objection. And you should know something else. Lawyers during these depositions are not permitted to make speaking objections. Now, what's a speaking objection? It's where the attorney gives a whole long-winded explanation about why my question might be inappropriate, with the subtle implication of trying to influence the doctor if he's allowed to answer the question. So here's what I mean. Let's say I go ahead and ask an off-the-wall question. Now attorney number two says, I object because that's totally improper, and he's asking a question that calls for this, this, and this, and this. And now that signals to the doctor that this is inappropriate and he shouldn't be talking about those things, and for the following reasons. So now what has she done? She's given basically the answer to the doctor about why he shouldn't be talking about those things. And in fact, we have specific rules that says attorneys cannot make speaking objections. You can raise an objection, you can say objection, that's hearsay. Objection, that's privilege. That's fine. But to go ahead and give long-winded explanations, that is not proper. Okay, so that is the role of attorney number two, to sit there quietly, to observe, and when I am done questioning, if attorney number two has questions of her own, yes, she's entitled to ask the doctor questions of her own. That's fine. But now, let's get back to the title of this video and what happened in this particular case. In this particular case, this was fascinating. This is something that I've never seen in 32 years of practice an attorney do. So now I'm asking the doctor a series of hypothetical questions. And now, the attorney who represents the doctor is allowing his client, the doctor, to answer these questions. I now ask the doctor another hypothetical question. Doctor, I want you to assume that the following facts are true. In that instance, would you agree it would be appropriate medical care to do X, Y, and Z? And now, attorney number two pipes up and yells out, objection! That's totally improper. I direct this doctor not to answer the question, and she said, I am not going to allow this doctor to answer your question. What? First of all, attorney number two has no right to say anything like that. She does not represent the doctor whom I'm questioning at the moment. So she has no control whatsoever over what this doctor can or cannot do. That's problem number one. Problem number two is that she made a speaking objection to influence the doctor about what to say or what not to say in response to my question. Number three, now because of her jabbering objection, that influenced the attorney who did represent the doctor whom I was questioning. And then he turns to me and says, you know what, counselor? The more I'm listening to attorney number two, the more I realize she's right, and I'm not going to allow you to ask this doctor those hypothetical questions. And now he and I begin having a legal argument, you'd call it a discussion, explaining why I believe he was incorrect and why I believe attorney number two was incorrect. And we took a break at that point. When we came back from the break, attorney number one tells me, look, we've discussed this. In my opinion, I am not going to allow the doctor to answer your hypothetical questions. What you can do is you can ask the doctor those questions. I'm going to object and direct him not to answer. I said, fine, then I'm going to create my record, which means I'm now going to ask each of the questions that I need to ask for this doctor. You can go ahead and make whatever objection you want, and if you go ahead and improperly tell the doctor not to answer the question, I will have no choice but to make a motion to ask the judge formally in written format to compel the doctor to come back now to do a second deposition to actually answer my questions. And you know, there have been instances where an attorney has done that, where we have had no choice but to go ahead and ask the court to intervene and ask the judge to compel the doctor to return back for a second deposition because one or more attorneys were being obstructive and doing things that they were not permitted to do and should not have been doing during the deposition. You should also know one last thing. In those instances where the judge finds that the attorneys have acted improperly, willfully, and intentionally obstructed the deposition, in those instances, the court has the ability, and in the past, in some instances, has fined and sanctioned the attorneys for their conduct in obstructing the free flow of the deposition. Depositions are fact-finding instruments that we use to go ahead and learn information. Just because the defense attorney doesn't want us to learn that information doesn't give them the right to tell the doctor not to answer the question. In almost all instances, except for a couple of those exceptions we talked about earlier, the doctor will always have to answer those questions. So why do I share this story with you? I share this story because I found it fascinating that this actually happened in today's day and age. And I wanted to share it with you just to give you a real sense of what goes on with some of these pre-trial question and answer sessions known as a deposition. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit but are thinking of doing so, but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a fascinating day.